Hello and welcome to Number 5 Chambers' inaugural podcast to our conferences and seminars on all matters planning and environment. I'm Hashi Mohammed, a barrister at Number 5 and your host for this hopefully informative podcast. And of course, no day full of seminars would be complete without a case law update. And we have the first part now for you. And joining me, I have Leanne Buckley-Thompson and Scott Stemp. Good afternoon to you both.
Good afternoon, Hashi.
Afternoon, Hashi.
Leanne, your paper looks at the case law dealing with Section 73 and Section 96A of the Town and Country Planning Act 1990. First, if I may just start with Section 73, what are the key cases that delegates ought to be aware of?
Well, Hashi, there are two cases that I'd recommend people consider when it comes to Section 73. Those are Lambeth and Secretary of State for Communities and Local Government, and the case of Finney and Welsh Ministers. To perhaps give a taster of each, Lambeth serves as an important reminder of the care required when granting variations, though there isn't anything particularly new to see here. The court restates the starting point in Trump of considering the natural and ordinary meaning of the words viewed in their particular context, and in light of common sense, so looking to the reasonable reader. His Lordship's comment as to the operation of planning conditions attached to original permissions, which aren't restated, despite a Section 73 permission being standalone, is definitely something to watch, particularly where you're dealing with a considerable planning history on a site. In terms of Finney, that brings helpful clarity with regard to the extent to which a Section 73 application can vary the terms of planning permission. The operative part of the permission cannot be varied. This should be borne in mind, therefore, when considering such applications. Where the imposition of conditions would alter the nature of what's permitted, it would be unlawful, such that clearly the Section 73 application shouldn't succeed.
And in terms of then Section 96A, what are the sort of latest developments in that area?
Well, Hashi, there's one case I think should be of particular interest to people, and that's the case of Fulford Parish Council and City of York Council and Persimmon Homes. Ultimately, the upshot of that case is that it clarifies that the statutory power in Section 96A does include the power to make non-material changes to conditional approvals of reserved matters. It also provides a helpful reminder that planning permission is a package of the grant, so together with any conditions imposed at grant or subsequently. Proposed changes must, of course, still meet the test of being non-material.
Thank you very much for that, Leanne. Just picking that up with you, Scott. Now, the relationship between 73 and 96 and how that impacts the question of community infrastructure levy, that's also somewhere an area where we've had a bit of development, isn't it?
That's right, yes. The case of Oval Estates and Bath and North East Somerset Council was before the High Court recently, where the court considered the different approaches the civil regulations take to Section 73 applications and Section 96A non-material amendments. And the court ruled that actually the civil regulations give no basis for any special rule or treatment under a Section 96A non-material amendment when you're assessing the extent of chargeable development. So Section 96A non-material amendments don't benefit from the same special treatment under the civil regs that a Section 73 application would.
And that's in the case of Oval Estates that you've just been telling us about. Now, just moving away from that Section 73 and 96A, what are the wider points that came out of Oval Estates that's going to be quite useful for practitioners out there?
Well, the wider point from Oval Estates, I think, is something everyone can relate to at the moment, is whether you can pay later in easy instalments for what you've got now. Oval Estates really concerns the assessment of civil liability and phase development. It wasn't clear in the case of Oval Estates that when the outline permission was granted, that it was intended to be a phase development. And in fact, the phasing only became clear later at the reserved matter stage and with subsequent documents then submitted. And the High Court ruled that when the assumption of liability was taken by the developer, that related to the development granted under the outline permission, not at the reserved matters. And since the outline didn't refer to phased development, still liability was calculated for the full extent of development, not in phases. So they ended up footing a bill for nearly £875,000 in one go instead of paying across 3 phases of development.
Well, that's definitely something that's going to be relatable for a lot of what's happening around the country. That's Scott Stemp and Leanne Buckley-Thompson helping us out with the Case Law Update Part 1. Thank you to both of you. You've been listening to the Number 5 Chambers podcast, giving you the latest updates on all matters planning and environment.